I'll get it in a minute. I'll find it. Are we ready? We are ready. Okay, terrific. So we are all set now for Jane's discussion with us on commercial motor vehicle law and spoliation of evidence, which we kind of led up to a little bit this morning. So I'll turn this over to Jane. Thank you.
Thank you, Heather. All right, we're back. I don't know who hates me. They put me on right after lunch. Everyone's kind of sleepy, but maybe they'll miss some mistakes if I make them. All right, make sure I'm up there. All right, so spoliation of evidence. So this sort of dovetails, from our discussion this morning. We talked about, a bunch of different issues that come up when you have a trucking case, when you have a CMV case, as far as discovery, use at trial, claims and defenses to pursue up until trial or at trial. So spoliation it doesn't come up in every case, but it's an important issue to have knowledge about, to sort of know where you stand, either plaintiff or defense, what you can allege as a defense. In my case, when that issue comes up, when you get that phone call from the plaintiff's attorney saying, I asked for X, the surveillance photo, or I asked for the trip logs, or I asked for a fill in the blank, and it appears that the discovery request was responded to by saying we no longer have that, that was destroyed, or our usual retention is only 6 months, and you requested it after those 6 months, and then in that conversation they say, well, I am going to seek a spoliation of evidence, jury instruction at trial, and then we have to discuss and fight about that. So let's sort of get into the law aspect of it. All right, so just the legal standard as enunciated in Rodriguez versus Schutz, which is a Colorado appellate case, 1994. Destruction of relevant evidence may give rise to an inference that the destroyed evidence was unfavorable to that party, and sanctions are appropriate or proper when a party has a duty to preserve evidence because it knew or should have known that litigation was imminent, and 2, the adverse party was prejudiced by the destruction of the evidence. Okay. Furthermore, where a party intentionally destroys evidence to prevent its introduction at trial, the trial court clearly has the power to employ an adverse inference as a sanction. In addition, such an inference may be appropriate even if in the absence of a showing of bad faith, in order to remedy the evidentiary imbalance created by the loss or destruction of evidence. So going back to that first slide where it talks about the legal evidence, when I get that phone call as a defense lawyer and I am told, look, this is coming down the pike, we are going to ask for this type of relief. And when I talk about the instruction, I have it in my materials, but I didn't make a slide of it. But this is sort of an exemplar spoliation jury instruction. I took it from one of the cases I was researching regarding the issue. So imagine this, there's a jury, you're there as a defense attorney or a plaintiff's attorney, and this is one of the jury instructions that's given. It is the duty of a party not to take action that will cause the destruction or loss of relevant evidence, hindering the other side from making its own examination and investigation of all potentially relevant evidence relating to whether that party's fault caused the incident in question. You are instructed, you may infer, by reason of the defendant's failure to produce these documents, that the evidence contained in such documents was unfavorable to defendant. My first take on that is that's really, really wordy. And maybe for federal court that would be appropriate, but I could see if I had to have this instruction, I would be, fighting to at least cut this down to maybe, 4 sentences less, or making it a little less wordy or legalese. But anyway, I found this as actually an exemplar of one that was proposed in one of the cases. I think it was an appellate case. Anyway, so that's what we're talking about. When you get that call as a defense attorney, that is an instruction that you're facing if you don't know, if the facts don't show that you can fight it appropriately. All right, so as a defense attorney, I get the call. I look at point 1, point 2, and that's where I look and I say, how do I defend this? And so obviously discreetly, the plaintiff, who's the party that's going to say to the judge, I'm entitled to this, I want this instruction, they have to prove, 1, that the party had a duty to preserve the evidence, right, because it knew or should have known that litigation was imminent, and then 2, I like the and, the adverse party was prejudiced by the destruction of the evidence. So as we're going to get into it, as a defense attorney, if I have to defend against a claim, hey, we get the spoliation instruction inference, I'm going to hope that I can develop evidence and facts, and the facts show that one, the documents or the evidence or the information at issue, that they were destroyed or they were not kept before there was any knew or should have known that litigation was imminent fact. That there's no facts that show that we should have, my client should have known that that should have been kept, that would have been relevant, and that litigation was imminent. And then two, even if I don't, if number one doesn't work out for me, number two, I still have that, it doesn't look good for my client. It looks like maybe they should have. They should have known, or they did know that they should have kept it and was arguably relevant, and yet, lo and behold, the evidence is missing. I still have a shot as a defense attorney for my client to say, well, number two doesn't fit or doesn't apply, so you still don't get the instruction because you can't show, plaintiff, that you were prejudiced by the destruction of the evidence. So it's a two-pronged sort of defense. That's how I look at it. Obviously, a plaintiff will look at it and say, all right, well, I got two things I have to prove, and if I do, I'm golden and I get the instruction. All right, the Colorado Supreme Court, in its 2006 decision in Alloy versus Union Pacific, found that a showing of bad faith is not required for an inference instruction to be properly given when evidence is destroyed. And they focused in their decision that, because different jurisdictions, they have to, one jurisdiction will say, well, there has to be bad faith. It's not enough, if a defendant says under oath or there's evidence that, it was just a negligent. They didn't mean to, they didn't realize. Even if the first prong is granted or the first prong is reached, the court, in this case, Alloy, says, you know what? If it's damaging to the case, if it's damaging to the plaintiff, it causes the same damage, whether it was done in bad faith, whether it was done intentionally, the destruction or the loss of the evidence, or whether they just did it negligently. So in that case, Alloy, Colorado Supreme Court, they focused on the damage to the plaintiff's case. So if it's damaging enough, again, that second prong, it seems like it wins the day, at least with the Colorado Supreme Court. And so it's really important as a defense attorney in Colorado, if number one, if there is evidence, and the court feels there's evidence that shows that maybe the defendant should have known or did know that they should have kept said evidence or document and they didn't, number two is crucial to be able to block that jury instruction, or at least make some good arguments for a later appeal. All right, so defending against a spoliation claim. When does a commercial motor vehicle driver or carrier know, or when should it have known, that litigation was imminent? And so, it's different in other cases. I was thinking in doing this preparation, like I said, I do a lot of premises liability cases. It's different when we're talking about trucks, especially big trucks, especially, the CMVs, the 26 and 1,001 pound vehicles. When an accident involving that type of truck or that kind of vehicle is involved, I'm not going to say that litigation is imminent. Absolutely, once the crowd's clear and the police tape is put up, everyone involved is going to know, there's going to be litigation. But I know from my own experience, if it's a significant enough accident involving a truck, that the insurance company gets involved right away. I get a call, and I sometimes get a call on the weekend at night saying, hey, a big accident happened on such and such in Broomfield or wherever in Weld County. Go down there, get an expert, because you want to preserve. So in that way, that's good, right? So we're getting a lot of evidence preserved. But as Heather touched on in her discovery portion of today's presentation, it really comes down to the driver and the carrier. So she's right. You don't want to forget that important piece. You're there. You're almost Johnny on the spot. If you get the call saying the accident just happened last night, or it happened today, get your expert down there. You don't want to miss that step of making sure you get, and you won't even have talked to probably the trucking company yet, but you want to make sure you talk to someone there and just say, they may already know, but make sure you tell them anything related that you think might be relevant. Hang on to that. If there's any question in your mind, give me a call, let me know. I'm the insurance company lawyer, they've hired me, I'm here to help you, we're investigating the accident. So please keep anything arguably, and then if you're about to destroy something, give me a call just to make sure. And that way I can sleep better, you all can sleep better, knowing that we're not going to have this type of instruction coming down the way against us if there is a trial. And no, just because there's a big trucking accident does not always mean there's litigation. But if an attorney like me gets involved, I know I usually send what's called a Hawkins letter. and I usually just say Hawkins letter, but I actually wrote down it's Hawkins versus District Court, and for the 4th Judicial District, it's 638 P. 2nd, 1372, Supreme Court case 1982. And so that's like just slang. When I, get notice of a trucking accident, I'm investigating. The insurance company says, handle this, hire an expert, let me know how it goes. I send out a Hawkins letter. I tell my staff, please prepare a draft Hawkins letter. I'll sign it, and I'll send it to, and usually I'm sending it to the client. I'm sending it to the insurance company, because usually then we're not sending it to any potential claimants, because again, we don't know if there's imminent litigation, but it's me being cautious. In that letter I say, this is to let you know that I am taking over the investigation, and as of whatever date, in my letter I'll say, as of this date, and plaintiffs' counsels have seen these letters, I was contacted, told about this accident, and I am controlling the investigation and the defense of this action from this date forward. And then I mentioned the Hawkins letter. The Hawkins case, and then I also cite to K Labs versus District Court and Compton versus Safeway. And in the letter I say, because this type of investigation with a lawyer getting involved and directing the investigation of this type of claim, this is not activities normally undertaken by an insurance company, right? Because, in normal discovery, especially when you're doing your initial disclosures, defendant, you usually, looking through a claim file, and you have to figure out, what date, unless there was litigation filed, boom, in the middle of the claim file, you have to find out, is there a date that isn't super clear, but it's one that you can reasonably rely on as the date that litigation was imminent, was anticipated, and that we say pursuant to Hawkins, from this day forward, the claim file is withheld because it was created or was developed in specific anticipation of litigation. So if that letter's there, right? So we look at knew or should have known when we're looking at evidence. Heather mentioned a preservation letter. We often get those as a defense counsel. A plaintiff's counsel will send over to the insurance company as part of the claim file, where it says, insurance company, I represent the plaintiff injured in this case. This is my letter to say, please preserve, and they're usually pretty detailed, please preserve X, Y, and Z, a whole list of things. They don't even have to say anticipation of litigation, but they just say, please preserve. So certainly when a defense counsel is fighting a spoliation instruction, saying, no, that's not correct, a plaintiff has a pretty good timestamp there to say, look, here's the date, Your Honor, that I sent the defense or I sent this company a preservation letter, and it looks like things were destroyed afterwards. And obviously then the onus would be on the defense to say, well, wait a second, let me explain. And I think one of us talked about, there's federal guidelines of how long things have to be kept. PUC has their own guidelines of how long, lawyers have guidelines, how long they have to keep their files before they're destroyed. So obviously that's going to be some evidence that a defense counsel will get to say, Your Honor, this was the usual, or I could see this is the usual retention policy that my client held on to was, 6 months. They would hold on to it and they would destroy it, and then make the argument, well, we didn't know or should have, we should not have known that there was going to be litigation, so we didn't keep it, and therefore there should not be, it's not an appropriate sanction to have this instruction given to the jury. So that's evidence. My Hawkins letter, I certainly can't, Rule 11 and all that, I can't be looking at the court and saying, well, I didn't know. How did my client know if I myself sent the Hawkins letter, right? So my Hawkins letter is announcing with bells, we are anticipating litigation. That's why I am involved, right? I cite to Hawkins specifically. That's a letter, I'm stuck with that date as the lawyer. And again, like I mentioned, with trucking cases, it's different than with other cases. I think of my slip and falls. Usually, right, like a gas station or a store, and they say, give me the surveillance, the surveillance camera footage from X, and it was maybe a slip and fall on juice or something in the aisle. And so it's a little easier to say, well, it wasn't a 3-car pileup involving, right, a multiple commercial motor vehicle, with fatalities or significant injuries. This is a slip and fall. The lady said she was fine. She wrote out the incident report and walked out. That would be a good argument, right, for everyone, defense, the company, the insurance company, to say, why would we, just on that basis, be telling because usually they recycle those tapes if you've had those cases. Surveillance, it's expensive to keep those surveillance cameras. So either sometimes the surveillance camera isn't working, or they delete every time they have a video, they delete the next day, or they delete 6 months, or that type of thing. So if that's the evidence, again, if it's not involving a truck, I think a judge is going to look a little closer. If it's a big-time trucking accident, I think it's going to be harder for the defense to say, to argue and to win that maybe we didn't know and we should not have known that litigation was imminent or would occur. Well, we can certainly fight about that. And what's funny, too, is that, not often, but plaintiff's counsel will sort of get in with me and say, well, I just looked at your initial disclosures, and you have the Hawkins, anticipation of litigation date as X. And why do you have that? Because I didn't file suit until X, and I just said, this is my settlement demand or whatever, and we have a little, give and take about that. It'd be interesting. I haven't had a case like that yet when they're trying to push a spoliation, and I'm saying, well, wait a second. You were arguing with me as to when my Hawkins date was, and now you're trying to use it against me. See what I mean? To say, well, no, it wasn't imminent, when I was saying it was imminent. So it was like the imminent versus not imminent battle, and we'll see what happens there. But that hasn't happened to me personally, but I was thinking that too. We always, as the defense, we're saying, it is imminent, but in this case with the spoliation, it's in plaintiff's best interest to say, you should have known right then and there, Johnny, and you should have kept this, and you should have kept that, and you should have, frozen the data, and all this different stuff. But usually the shoe is on the other foot. Okay, so when was item, evidence, document destroyed or discarded, pre-litigation or post-litigation? And then what does the case law say? So appellate court, 2006 decision, Castillo versus Chief Alternative LLC. Courts typically impose sanctions, which would be this instruction, other sanctions too, but to me the instruction is key, for pre-complaint destruction of evidence only in 3 circumstances. 1, where a clear showing has been made that the defendant knew litigation would be filed and willfully destroyed evidence it knew or should have known would be relevant to the case. That's what we've been talking about. 2, where a party is engaged in a series of lawsuits and destroys evidence after litigating the first lawsuit but before another lawsuit has been filed. All right, that's a gimme. That would be quite a bold defense attorney to say, yeah, that went to trial, we struggled with it for 3 years. But I had no idea that we still have to keep it even though, the second lawsuit was coming. So I certainly get that one. And then the third one's intriguing to me, where the spoliator is the plaintiff. And I can't even imagine what that would be. But I think I think Chad gave the example, I can't remember who did. Heather did, about the cell phone, that somebody, the victim's advocate grabbed a cell phone involved in the case and gave it to the victim's family. So if we play that out, if maybe there was a phone and we don't know what was on it, and then it disappears and the evidence is it was in the plaintiff's custody and now it's gone, I guess then that would fit in, and they would say, there will be sanctions because of that. And I guess sanctions obviously not against my team, but against the plaintiff. So again, playing into these 3 circumstances, that changes if there is, the preservation letter, right? That would change a date. That would mean that probably pre-litigation, that means nothing if someone, either side, sent a letter saying, stop, please preserve what you can preserve. Okay, another situation too, again, from the defense is when you're looking at why was this destroyed, and you're looking to see, do I have any defenses as to why it was, if it falls into this sort of bad category of knew or should have known. And I think it depends on how sophisticated your client is. If I have a mom and pop trucking company and it's not, again, we talked about this morning, in violation of any federal motor carrier regulations as far as keeping things, if it's something that they didn't know they had to keep, it was something that they would testify under oath, that we thought that it would stay on the computer, or we thought it would be accessible and it didn't. Also, too, I have some cases where people say, the plaintiff's discovery request will be so far-reaching and say, could we have something for the last 3 years? And I often call and just say, look, they're asking for this. I haven't decided, what would be reasonable within the parameters of the case. What can you get me? Like, if we were forced to, if the judge said, give all 3 years, you gotta. Could we? And and you all know, sometimes they'll say, well, we changed computer systems, or we had, there was a crash, and so they give what they can. So I didn't find any cases that said, but again, there is that negligent versus willful and wanton. I think if it's really hot information, really hot evidence, and very relevant to the claims and defenses, I think pursuant to the Alloy decision, I think we'd have a hard time. We'd say, but we didn't mean to, and we didn't know, and it crashed. Could a judge say, well, according to Alloy, it doesn't matter the why or the where. if it could have been helpful to the plaintiff or it could have really, hurt your case defendant, I think we're going to give the instruction. All right, and again, if the spoliation letter was sent by the plaintiff's counsel, when was it sent? Again, what's that date? What's that preservation date? And same thing with defense counsel. I can do all I can when I first get it, and certainly if I get it, within 24 hours of the trucking accident happening, I am all over it. But there are those cases where it's the statute's almost up 3 years. I get the case. Well, I can't. The horses are already out of the barn if things haven't been done. Same thing with plaintiff's counsel. What if you are hired, almost close to the statute or 2 years into it, if things have been destroyed, or if it's one of those cases where it isn't a big significant trucking accident and it's litigation isn't written all over it, would the plaintiff's counsel sending a spoliation letter as soon as they get hired? It'd be reasonable for someone to say, well, thank you, attorney, but, we didn't dream. This is such a surprise to us that you're bringing this litigation, and we didn't keep the surveillance, or we didn't keep the trip logs, or we didn't keep whatever. All right, here's the big one. Again, it said no matter how bad a facts you have as a defense, if it looks like, God, you really should have done it, whether willful or wanted or negligent. So you don't have to beat your client up and just say, whatever reason you don't have what they're asking, let's move on to right prong 2. Was the adverse party prejudiced by the destruction of the evidence, i.e., is the evidence really relevant to the claims or defenses in the case? And we have all seen, and Heather touched on it, so many discovery requests, and they're beating their breasts and saying, we need this, and it's important, and you're saying, how could that possibly or potentially be relevant? And I know in certain cases, too, when I'm legitimately fighting on that, I'll just say, look, I don't want to put it in a supplemental disclosure. They say, like, Rule 121 confer, you should have done this. This is in your privilege log. We're entitled. We need to know if the trucking company, actually, it was like a driver file thing. And it was like last week. And I said, look, I don't want to put it in a disclosure document because it's me saying, Rule 11, as an attorney, this may be relevant, right? Discoverable and relevant. I said, so I'll send it to you in an email, with a bunch of, like, this is not a waiver, yada, yada. We are still affirm our a privilege log objections. So I sent it and I said, here it is. But a lot of times there's nothing in it, as Mr. Plaintiff's attorney back there said, we don't know what it is. There might be some amazing, right, John Grisham novel type, right, mystery document that's going to blow this plate, right? Oh my God, where's Sandra Bullock? We're going to cast her. No, so it usually isn't. It usually isn't that. But so sometimes you want to just be like, put the guy or gal out of her misery and just say, look, it's the most boring thing you've ever seen. There was one that was like new driver, and they're like, oh, but he was hired like 2 years before. Why is he getting the new driver checklist? And I said, look, off the record, truck, and I like it, truck driving companies, whatever, they update their safety materials and their training materials, and they'll be in business for 10 years, and then suddenly they'll say, oh, I like this new checklist that this other company, and so then they use it. I said, no, he's not a new driver, but he did so I sent it. I said, here's the checklist, flying colors, and and he'll you depose him, and you have his application. He was working there a year before, and if you're going to get anywhere, you're going to want to find out, was he trained, etc., and what was he doing at the time of the accident, right? And they were like, thanks, I appreciate this sort of, informal, here it is, it's nothing too exciting. But I get it, you thinking like, man, they're sitting on a gold mine of stuff that I could use, and usually it's as boring as dirt. So if you can, sort of explain that, then they can get less excited, and then we can actually move on, right, to actual relevant, exciting stuff in the case, make or break the claims and defenses. So, all right, so I'm very interested, was it prejudicial? And actually, we can't get away from Farrer, right? We're wedded to Farrer today. But in Farrer, there was actually a spoliation item in there where, excuse me, part of the motion to amend the complaint to add exemplary damages was based on an allegation that Yellow Cab purposely was, they were telling their drivers to destroy their trip logs, right, their driver trip logs for the day, and that, that had arguable relevant evidence. And actually, like during the hearing with the Supreme Court, they actually got into that factually, which I thought was strange. They were explaining it, and that's why there's a big discussion in the decision, which normally it doesn't happen. But what happened was this, again, sounds so exciting and it really isn't. They were going for, these trip logs would have shown that he was driving in excess of the PUC regulation of how many hours you're allowed to drive. But the way the trip logs were, and I guess they showed the trial court, and the trial court was satisfied as well as the Supreme Court, the trip logs only show how long they're on duty, which doesn't mean they're driving. So it was, I think in the hearing, he was saying, well, if you figure it out, yeah, I swear. He's like, well, he started in Dry Creek, or he started in the tech center, and he drove to DIA. I thought, this is what the Supreme Court, do they really care? But he explained, he's like, this whole day he was driving, he only made 3 trips, from, DIA to the tech center to take people to and fro. So that makes sense. So I think everyone heard, they're like, all right, it sounds exciting, like, oh my God, he's been driving for 12 hours, he's bleary-eyed, doesn't, or of all these hours, he had 3 taxi drive trips, and the other time he was listening to NPR or whatever he was doing. So there was that. So the Supreme Court said, no, that's not enough. And again, they specifically said, even if you did get that information, because they were seeking that as part of like the big discovery, give us your driver file, give us this, give us that, that even if it was introduced, it has no relevance. It doesn't help at all plaintiffs' claims against the driver or the company. All right, where there is no extrinsic evidence whatever tending to show that the destroyed evidence would have been unfavorable to the spoliator, no adverse inference appropriate. So, that's pretty significant language, where there is no extrinsic evidence whatever. So that's sort of a high burden for the defendant. But again, sometimes it is what it is. On its face, the document in the driver file or whatever, it just shows there's no, and the defendant has to say, how do you take this document, how do you get to negligence of the driver? How do you get to whatever claim it is? There's just no connection. And as the Supreme Court in Ferrer said, we all have a concern. All the jurisdictions have a concern. We don't want to bring in all this information that really is ancillary, has nothing to do with, but all it'll do is inflame people, right? So the companies in it and the driver, they're madder at the driver and at the company because of some PUC violation or some federal regulations. They didn't do document the trip test correctly. It's not a good company. But what does that have to do with the negligence at the moment of the accident that this jury is supposed to look at? So confusing to the jury. There's 403 written all over it, says the defense attorney. Right, Jen? The Colorado Supreme Court in its alloy right to draw an adverse inference from the absence, loss, or destruction of evidence, it would have to appear that the evidence would have been relevant to an issue at trial and otherwise would naturally have been introduced into evidence. So I think I would use this as a defense counsel and just say, let's look at alloy and just say, plaintiff, explain, offer proof. How would this, right? How would you get this into evidence? So first, is it even admissible? And then again, how is it admissible under 401 and 403? Okay. As far as other spoliation cases that I was looking through appellate court, again, surveillance camera is one. Sometimes you need an expert. I was saying, different spoliation cases I've had, an expert to talk about how it could have been retrieved. Sometimes there's surveillance cameras that cannot, for cost effectiveness, you cannot retrieve it. I guess you could retrieve it with a computer hacker, that type of thing. But again, if you have a mom and pop type of company, then it is not. It's easier for the defense to say, first to argue to the court, and then as well as with the jury to say they didn't know, they didn't have the technology in which to do that. I'm trying to think of other things that I saw for spoliation. With the Hawkins letter, especially, I try to be all-encompassing with that. But then when it comes to, again, that prong number 2, I want to make sure that it's relevant, it's not relevant. In light with the Ferrer decision with spoliation, I think that that too comes into play. Again, we can't get away from Ferrer. But certainly it's going to be a fight, I think, from both sides. If it's an item that appears to have been destroyed or is no longer available, and it falls within or could fall within, give me your entire claims file, or give me your entire driver log file, that type of thing. Cell phone records. I want to talk about cell phone records. As Heather pointed out on her item, it seems like every trucking case, actually every car accident case these days, cell phone use is a big deal. And just recently, not just related to trucks, the cell phone, there's been, and tell me, I'd be interested to know from plaintiffs' attorneys if they have cases where they can say, I just got a great order where willful and wanton, at least prima facie for exemplary damages, was granted because it showed that a driver was using a cell phone. Because alternatively, again, I'm the defense world. I only talk to defense attorneys, usually. I have a few token plaintiff attorney friends, I'll have to say that. But, when we get together, in the evil, yeah, sure. Yeah, notice no one's jumping up. I'm her friend. Yeah. Nobody likes her. But when I talk to my defense, when we get together for our evil den meetings and we talk about cases like this and cell phones, I think maybe a couple of years ago, I really was nervous about the cell phone. And I remember saying, look, we need to get the records from the company and we need to get the records from the driver. And did he have a personal cell phone? And this timeline is crucial. And, when was the last call? And, is this truly the call to the boss? And who did he call afterwards? And is this witness going to say he was telling me a joke over the phone when this happened? But I've seen a lot of orders even just recently, where court after court after court is saying use of a cell phone is not. In fact, one court said, use of a cell phone is kind of dumb. It's in fact not reasonable. Again, with the jury instructions saying what's reasonable conduct when you're driving. Using a cell phone probably is not reasonable, but it does not reach the level of exemplary, willful and wanton, that type of thing. But let's apply that to, that's just a regular car type stuff. Let's apply that to a truck. I talked about in my first session about a jury, whether we want them to or not, may expect more from my truck driving driver. That they're going to expect, even though I say, my truck driver has the same reasonable standard for driving as this plaintiff, I feel like if I do my job and my truck driver comes across the way he should, they're going to be like, wow, he really knows how to drive a truck. He's driven all kinds of weights and dump trucks and this and that, whatever. Aren't they going to hold him, though they shouldn't, to a higher standard? Same thing with a cell phone. You think it's a bigger truck, and usually with these trucking accidents, the terrible damages, significant damages, fatalities. I think courts may reasonably look at that differently. And I don't know, and I have not had personal experience with that. But certainly with cell phone use, there's higher scrutiny. And then I want to find out, are there no hands held? Can you explain? We talked about truck inspections, how people come down and the plaintiff says, not only do I want to inspect your truck, I want your driver there. I want him to sit in the seat. I want him to adjust it. The experts, you bet, are taking pictures of where is if it's not non-held, where is what do you have to do to dial it? If you get a call coming in, what do you do? And they're still, even if it's all perfectly legit, if it's all federal regulation, if it's affixed to right next to this thing, he doesn't have to touch it, it just automatically, sometimes they do, the call comes in. Even then, I think plaintiff does still argue distracted driving. He's driving a semi that's 80,000 pounds loaded. He wasn't paying attention. Someone was calling in. This shouldn't have happened. And again, this distracted driver. But again, the exemplary damages thing with cell phone, I think that it's still a hard burden for the plaintiff to prove because it just isn't. Drunk driving. So I was trying to think, what's a sort of, you're stuck, exemplary driving. If you have a drunk driver, everyone hates drunk drivers. Everyone has a friend or, a relative that's been injured or hurt or killed, God forbid. People are mad. So I can't imagine willful and wanton to be drinking and driving in a truck or anything, right, on a bicycle. Not a good deal for a defendant. But with cell phone, I am very careful in the discovery. And then, we don't want the cell phone records. But I've had cases, though, against spoliation, where I talk to Joe Driver and I say, I ask for the company cell phone and they say, well, we didn't think to keep it. We didn't think there was litigation. There was no preservation letter. There was no Hawkins letter from a defense attorney like me. What will the courts do with that? You wonder. It's going to be the argument. Plaintiff's going to say, look, they were on, I think he was on his cell phone. They knew that we were going to sue. My client got really hurt. And suddenly they didn't call Sprint. They didn't think to call Sprint and say, hold this. Because certain providers, as I've done this, I've called them up and the person says, they only keep it 6 months or they only keep it 1 year. And then other ones are really great. I don't know which ones are great. They'll fax right over to the client and then they're in my hands. And then I redact like wild. But yeah, so we don't know. So again, it depends on who the company is. Again, a juror's going to say, hopefully without this, jury instruction, why don't we have this? And we'll say, Judge, look, this is a mom and pop trucking operation. They thought it was just a car accident. Why would they think there was going to be litigation or a lawsuit? They didn't purposely destroy. Again, alloy, it's not a great decision for defendants as far as, we didn't mean to. But I think you can still argue if we didn't think litigation was imminent, why would we keep something, or why would we call AT&T or Sprint or something and just say, send us the information, that type of thing. But a lot of times I know some complaints will say, and the defendant was talking on his cell phone. And I'll say, where did they get that? I'll talk to my client. It just seems like sometimes it's like a wishful thinking, or maybe the client said, like, I think, I can't believe they didn't see me. He must have been on his cell phone or something like that. And then it's critical. I mean, I do get it, that the plaintiff says, I asked for these cell phones, Your Honor, records, and this is this rear end accident. Why else, did they not see my client's big Suburban, these cell phones? If we had these cell phone records, it would show that this person was talking a long, long time. And I think I as an example, I had that deposition when the co-defendant was saying, and he had his records out, that he had called, and it was like really close to when the accident happened. And he said, well, I called the weather, if you guys remember this, and it was like a 4-minute phone call. And so we were all, even defense were rolling their eyes going, come on. So that will be important. So for me, if you do have the records, you're looking, you're redacting before, who cares what's happening before and after, but you're saying it's so critical. What's that phone call? And then hoping that it's to the boss saying, hey, I got into an accident, right? Or like 911, then the boss, then, all right, I feel good. I'm like, this is all right. But yeah, if you don't have the cell phone records, you better have a good argument as to why you didn't think it was imminent. There's no preservation letter. I mean, to me, if the defense counsel, checks this out and the preservation letter came long after, if a company truck driving company or the driver can say, look, my company only keeps the company cell phone records X amount, and we got this preservation letter, 2 years after, you're feeling pretty good as a defense attorney that you're not getting that instruction. But if there's any other type of blurry lines, then maybe. And then again, when I do have those cases where you get the call in the middle of the night or during the day and you have an expert there, I think a judge would also have a heightened standard for you, saying, defense counsel, wait, you had the wherewithal, right, to have an expert. He's asking for the black box. He's saying where's the truck? Like Heather was saying, you have to sign something to get in to see the vehicle that was involved in the, if something falls by the wayside, that doesn't look good. That doesn't look good. So I don't know, what kind of information, because then you yourself as the defendant is saying, yeah, this stuff has relevance. We're wanting to preserve this. And then they didn't. So I myself have never had to have this type of instruction. I referenced earlier how I was watching that. We get to watch those jurors when we had that mock trial, the Denver one with Christina Habas presiding. I think, thinking about these types of instructions, I'd be happy to hear any stories where, you had a great verdict plaintiff and afterwards the jury said, wow, I can't believe they lost that evidence. Because more often than not, when you look at what was destroyed, unless it's a cell phone record, and even if it's a cell phone record, I mean, to me, if there's no extrinsic evidence, and again, if my trucker is who I want him to be, he looks a little scruffy maybe, but professional, he's got great experience. I know, too, I had a case where they were saying, where are these cell phone records? How come you don't have them? He was saying, and I thought that would sort of work well with a jury, saying there were so many cogs and gears that he had to work. He looked at me like I was a fool and said, how could I possibly hold a cell phone? Because it was a handheld. So he said, I'm not supposed to have a handheld. And that might have been a federal regulation. But he said they should come and see, the interior of my truck. What's a guy to do? Like, I don't have a third hand. So I said, all right, good, keeping that in the back of my mind. Like, well, if this really comes to something, then maybe. And then I've talked to some plaintiff's attorneys, too, about when, do you always want to go for the instruction? And I've been told not every time that it's fact-specific, it's case-specific. I think, Chad, earlier we were talking about there's certain trucking cases where, yeah, you have a whole host of things to go for, but sometimes you have a really great fact, right, against the defendant, or a really great theme or a claim against the defendant. You don't go after everything. I know when I'm looking at a case defending, I'm saying in my head, well, I hope plaintiff goes after this sort of wild hair over here, because then it appears like they're not as serious about the case, the claim that I'm really worried about. So good, let's talk about this one over here. So to me, let's talk about a case where the instruction does come in, right? I mean, I think it's going to be a strategy on the part of the plaintiff to say, how much do I want to make of this? Because I know as a defense counsel, whenever I want to go for some alternative theory, I usually abandon it saying, look, if there's no actual other, like injuries, if there's no actual other post-accident injury or something to point to. I know juries don't like that. That it's such like it's a question. It's maybe it happened, right? And then they also get those jury instructions to say no speculation. So I look at the instruction that I just read, that very wordy one, and I'm thinking, isn't that sort of speculation? I mean, they're telling you can infer that it's bad, but then off the jury goes, what did it say? What didn't it say? And I've had a plaintiff's attorney tell me that he doesn't want to worry that they're saying, well, he's so focused, right, on this instruction. He talked about it in his opening. He worked on it as a theme as part of the case, and in his closing he mentioned it, with satisfaction, like, just you wait. And he said, sometimes I'm concerned that if I say that and it's not something that I can prove or I have good evidence on, that they're going to say, why is he so excited about that? It's something that, could be, you should infer. Can he prove it otherwise? Like, don't the other facts, it's almost like racist ipsa, like, well, what else could have happened? And so again, I'm certainly not going to caution plaintiff not to do the wrong thing, but I've heard that's something strategy-wise, you do want to include it. Do you want to fight for the instruction? And with any case, you don't want to have appellate error if you go too far with the instruction and with the reasonableness. And certainly, and again, we always like to give litigation tips here. Like I said, defense counsel, if you have something and you're fighting so hotly, I'm not giving this to you, and they're saying, I'm going to ask for spoliation, like kind of in the Farrer case, and they're saying, give us these trip logs. Why not give it to the person informally? And so then they know it's not that exciting, and then the court can see it as well. And then actually, as the defense counsel, it puts the onus on the plaintiff, like, here it is. It was this exciting mystery document, but now that you see what it is, now you have to explain to the court, now that it's been unveiled, why or how it potentially could be relevant. I liked in the Farrer case when they were looking at, again, the spoliation and saying these trip logs, because they have to take it sort of on faith that, and also in the face of the documents, those trip logs, what they do and what they do not say. And obviously, as a defense counsel, I would say, Your Honor, what would have the cell phones records have said? Again, I think that's a loser. But some other type of document, like a trip log. I think with trucking cases, those are really important. I often get requests for that. Or, there's a lot of documentation federally that these truck drivers have to do, right? Weigh receipts. We're talking about weigh receipts and things along the way. And did they check in? And what if those are gone, right? What if those are gone and the plaintiff is saying, if only we knew what he said, because companies often have their own sheets that they come in and just say, great, I checked check the air in the tires, like the post-trip report. And if it's not federally regulated, but the company just does it on their own. They filled this out, and then they're gone, right? And a plaintiff has to argue what information could have been in there that would shed light on the accident. I think the plaintiff would say, well, we don't know because they've been destroyed and we don't have them. But I think you would have to extrapolate a lot, or you take a lot on faith to be like, well, what if it said brakes completely out? We were talking about the brakes completely out, or I was drunk, or, I went to Shotgun Willie's, or something like that in the post-trip report. And then, that would be something, again, a John Grisham moment, but that usually isn't. So the trial court said that we would take hold on, give me a second to find, because it's kind of interesting. Like, it would take a lot of, the trial court observed that Farrer's allegations against Yellow Cab required a lot of leaps of faith and a lot of connecting of inferences. So you bet I'll be using that, next time I have to defend a spoliation. I'll say, oh, counsel, don't you, in order to get from A to B, don't you believe that? And if the plaintiff's counsel on the other end, knows what he's talking about, or she knows what he's talking about, she'll say, well, you have to show, right, that there's no whatever. I don't like the whatever. No extrinsic evidence whatever, right, that it would potentially be relevant. But with trucking, like we talked about with the Farrer case, defense counsel is going to be even more and more aggressive about, you must narrow the scope. You must narrow the scope, and that would certainly include trip reports, things like that. And again, when you get a discovery request for a year of trip reports, a year of trip logs, and again, too, with the leaps of faith, with the spoliation, I would not want to be a plaintiff's attorney saying, Your Honor, they destroyed, not the day of, like that good defense attorney, she gave me, the day of and the week of, But we asked in our discovery for 2 years, 2 full years before this driver, because we wanted to see if there was a pattern of abuse, blah, blah, blah. I can't think of any judge that would say, you're right, I can't believe there was going to be a lot of reasonable, relevant information in that year before, and it's destroyed or it wasn't kept, and that gets you. It's really an extraordinary sanction, an additional jury instruction. How many trials have we all had, folks, where we're all excited and we have a tailored, it's usually plaintiff's counsel actually, a tailored instruction, usually premises liability, where they add those instructions where there's like case law on the bottom. I'm like, no way. And then the judge says counsel, and I say, there are form jury instructions for a reason, Your Honor, and then we both nod sagely. We love that, because then that helps also appellate. There's no, you just say, look, we use the form ones, we can't go wrong. But yeah, certainly with these, this is an extraordinary relief, and I feel like, with appellate, if you have a bad verdict defendant and this instruction was given, and again, plaintiff, right, I said they strategized, do I really want to lead with this, or I want to say, wait till you see what they got rid of? If there's not a good punchline there, if the jury's saying, is this all they got? Like they can't prove that he screwed up then and that he can't prove this. They're thinking that maybe he was on the cell phone talking to his girlfriend, but they don't know, but we're just supposed to infer it. Again, the whole issue of fairness there, I think that's a risk with the jury. And then, yeah, you do get it. I mean, how many times, too, you argue for a jury instruction and then in your head you're like, I can't believe, do I really want that? do I really want to be that successful? Because if it goes badly, then they have, I call it the appellate basket. They have a bunch of things in their appellate basket that they can wave at me, and then, then it's not so good, and then we're in the appellate court. So to me, that's another consideration out of the plaintiff's counsel is, are you creating, how sure are you? I mean, if you get a lenient judge, and you guys are both giving you a thumbs up, like, no problem, plaintiff forgot you, I think you get the inference, you might want to stop, of course, coming from the defense attorney, the wolf in sheep's clothing, but stop and just say, is it worth it? Is it that important to the whole theme of my case, that I want this spoliation instruction? Am I looking a little desperate? And if I get this, will this give the defense what they need? They can just go to trial, right, with impunity and just say, let's just see how it rolls out. And if we get a bad verdict, that instruction should not have been given. That's a big deal. That's an extraordinary sanction, and that's worth, saying that it was abuse of discretion, and then off you go. And then you don't get resolution in the case that you've been, working on for years. So certainly that is something to think about. As for spoliation instruction crafting, as I indicated, I think at the beginning of this, I think defense counsel, if you're stuck with one, I think you fight hard to make it very clear. And then obviously you're developing defense, you're putting a lot on the record leading up to the judge's decision as to whether you get the instruction, where you have to defend against the instruction. So make a good record and then fight for language. And again, like I thought that one was too wordy. Just make sure if your case is fact specific, anything you can get in there that maybe explains a little more. You can offer proof to the judge, just say, look, this is, get on the record with the judge. What are you saying? When you say, no, it's reasonable to think that this would have been relevant evidence and that this would have helped plaintiff's case, and if it had come to light, it would have hurt defendant's case. What is the factual basis for that? And then use that, if you have sort of a good case, to say it just squeaked by against you, to try to maybe get the most lenient language or the least instructive language against the defendant. But again, that's going to be between you and the court to see what happens. And then again, you might also end up with creating an appellate situation that you don't want to create. But my experience with courts, though, they don't like any kind of extra instruction, like I said, any new weird, if it's not in the jury instruction notebook. So again, in addition to it being extraordinary relief, I think it's going to take, again, a good showing of reasonable relevance before it gets to the instruction phase. And I would think so too. It talks about sanctions, and that one of the sanctions is this instruction. I think the worst sanction to a defense, you walking into the jury trial and basically, if they go as far as the plaintiff counsel wants them to, the jury's going to think, man, John Grisham has ruined it for defense counsel. Oh man, they had something hot, and they stuck it in the shredder. How many movies, how many TV shows do we see someone like happily shredding, some important document? And it's tough for defense counsel. I know, boo-hoo, but it could have had nothing to do, but it's just gone. And again, especially if defense counsel gets the case late, you didn't have a chance to do that. So again, you got to say, we didn't know, we should not have known. And again, how do you prove that? Hopefully you have some good facts. Hopefully, again, also helpful facts. When Heather was saying list of different discovery things, you want to know if there are documents. As a defense counsel, you know what the other side is probably going to ask you for. You say, look, do you happen to have these cell phone records? Do you have this? Do you have that? Find out ahead of time, right? And then find out, all right, well, how come? How long did you actually keep them? Like now we're 3.5 years after the accident. How long did you actually keep them before they were disposed of? And I think a big part of any judge's decision too, for that first prong is, was it done strangely? Like, was just this one document, it's gone. We've kept everything else. I think mostly in cases, the truck driving company says, well, we keep, PUC says that we have to take, taxi company, PUC says we have to keep it this way, or the federal motor carrier says we have to, so we keep it, everything, right? That's what I like. I like uniformity. We keep everything, not just, the trip log or something related to this accident. We keep all our documents. This is our set way. Great if we have a federal regulation to tie it to, but this is how it's been, right, since our company, Smith & Jones, whatever, was first created 10 years ago. I like those facts. Those are good facts because the judge, look, knew or should have known. We didn't go out of our way to run to the shredder after this accident, and that also, bolsters our claim. We didn't know that litigation was imminent. And certainly, again, those letters, who was a letter sent to, et cetera. I don't know if the judge is going to say, like, well, and I didn't see any case law interpreting, like, say the preservation letter is only sent to the insurance company. That's an interesting rub there. But there's the company there, right? They're the ones that need to know, and say the adjuster doesn't think, just says, oh, thanks, I'll put this away, and the adjuster thinks this is not going to go to litigation. I think that's important evidence. Again, for prong one. For prong two, the alloy court's tough on defendants, and they say, we don't. If it's really relevant, you make a good case plaintiff that it's arguably relevant and really could have either hurt the case or helped the case, whatever it may be. We don't really care why why we don't have it, why we're not looking at it today. So it's tough. I'm sure Chad's going to say more about this in a little bit, but that's what I got. Anybody have any questions or any good, stories about being crushed by an instruction? Right? No? Oh, yes, Max.
A question to see if anybody else has dealt with it. In terms of like the commercial trucks, the black box, say there's an accident, truck's fine, truck drives off, continues on its way. Any duty upon the carrier to pull the black box information to find out what happened in the accident if it's really not that big of a deal for an accident, the truck goes on for another 1,000 miles? Is it spoliation, or is it in terms of you didn't stop, take your truck off the road, pull the black box? When you have maybe a non-reportable accident, you went on your way.
Right. All right, so the question from Max is, I appreciate it, was, what is the duty? And I don't think it's been fixed on, but what is the duty? Say you have a truck driver that has a non-reportable accident, something happens, but the person drives away, there's nothing to do, and you have many, many miles to continue on. Is there a duty? Is a plaintiff going to successfully argue that driver should have said, preservation of evidence, I'm going to pull over, I'm going to call my boss, never mind the perishable, cauliflower that's in the back of my truck. No cauliflower for anyone in Will County today. But, I have to do this, I have to call in, et cetera, if it's one of those. And I think, like I said, when I think of truck accidents, I think of like the worst ones, because those stick with us. But with yours, I like yours because it's not like someone's, broken arms or crushed vehicles or whatever. It's one of those. So I think that's the best argument to say, Your Honor, when there is no black box, Your Honor, this was a non-reportable, this is the best scenario to say, knew or should have known? Are you kidding me? Like, not every accident. That's the whole thing is luck. Our luck goes a little far, I think, in my opinion, but at least it doesn't say every accident. Stop in your tracks, photograph everything, grab the expert, etc. So again, it's so fact specific, but if you have and again, but if I send that Hawkins letter, you're in trouble. But I say, oh, she thought it was relevant, that type of thing. But certainly, I like your example because it's sort of like a non-big truck accident, that type of thing, or a near miss, and that type of thing. And also, too, I think it helps, too, with experts. I learned, again, like I said in the beginning, I learned so much more about every trucking case I have. I'm like, oh, that's what that is, or, depending on what you have. And I think, too, an expert might be helpful to bring them into the hearing if you're really fighting that instruction, for them to say, look, this type of accident wouldn't even have shown up on it. That's the greatest thing. That's that prong two, boom, you hit it out of the park. Just say, Your Honor, they can't even, there's no way to prove, there's no extrinsic proof to say that it had anything, because look, here's this expert to say, I interpret black boxes all day long, and this wouldn't even a blip. There wouldn't have been a blip. Even if he had pulled it off and put saran wrap around the truck and called whoever he needed to call, it wouldn't have provided any good evidence. So, case closed, no instruction, that type of thing. Anybody else? No? All right, thanks so much, you guys.